Let's bring our News 13 legal analyst, Mark NeJame, who is standing by with more. Mark, thank you so much for being with us again this afternoon.
Pleasure.
We've talked about this before. Simply put, there are a lot of people who are watching this jury selection process very closely because they are concerned that this will not be a diverse jury. I can tell you so far we've got about 5 non-whites of the 18 that have been questioned so far. What is your take on what we're seeing on the racial makeup?
Well, I'm happy to see it. My concern has been that there would be an all-white jury, or that all who are not white, African Americans and Hispanics, may be stricken. And that could suggest that, in fact, it wouldn't be a fair and balanced jury. At the end of the day, we still don't know the racial composition, but we do know that right now it's skewing actually higher than the population of Seminole County. Seminole County is approximately 10% African American, 30% African American in Sanford. And what we're seeing here initially, apparently out of the first 100, about 10 of the jurors were African American out of the 100, which basically followed right in line with the racial makeup of Seminole County. And knowing that in the first 18 or 20 that we have, the 18, that 5 are of other than white, being Hispanic and or African American, we find ourselves with a higher percentage of minorities, at least in this first representation, than we do in the overall. I like that. I think that allows for a suggestion that all the more fairness is being injected into these proceedings. At the end of the day, we don't really know how the final 6 are going to shake out, but at least in this first vetting process, I should say the second vetting process, the first, there's already been, 40 people were removed. We're finding it to be pretty fair, and I find that the questions are well-founded. I find that the answers are well-founded. And what I also like is that we're seeing that people are simply not, and it almost sounds trite to make the analogy, but black and white in their thoughts, that there's many shades of gray, really much like our population anymore, which is not simply a black or white population, but many shades are defining us as people. And we're seeing that with people's opinions in the jury. They might be watching Fox, but then yet their son is wearing a hoodie all the time. It suggests that things are not so simplistic and cannot so simply be put into little containers and defining who they are just because they watch this or they wear that. And those are the areas that the lawyers have to get into deeper to find out truly what are these people about? What are their true philosophies? What are their true beliefs? And are they going to be able to be fair and impartial? And I'm very, very optimistic that we're getting a good jury here from these first groups of people that we're seeing. I like it.
Yeah, you talk about stereotypes. We talked about this yesterday, Mark, about even all types of deals, about even the young versus old. And you brought up the point about sometimes you see a young juror come up there. We've seen quite a few young potential jurors and think, I bet they're liberal. Not always the case, so you have to be careful about that. Another quick question for you, straight out of our chat room that I was hoping that you could answer for us on air. Again, our chat is cfnews13.com/chat if you want to join in on the conversation about, can Zimmerman still have a stand your ground hearing? A lot of people confused about that issue. Mark O'Mara passed on doing the stand your ground hearing. Some people were kind of surprised by that before the trial was to start. Can he still bring that issue back up?
Well, it's a hard question to answer. If he's going to bring it up, he has to bring it up now because you have to bring it up before the trial. And so he's got to bring a motion forward to say he wants to have a contemporaneous stand your ground hearing with the actual trial. We all thought that that's what he was going to do. And it doesn't look like he's doing that anymore. I understand there was an interview, I did not see it, on News 13, where he apparently spoke. One of the bloggers came in and said that he was not going to be asking for it at trial. I don't have independent verification of that, but it seems that's the direction he's going in. It's waived completely. If he's going to do it, he needs to do it now and have a motion in before the trial actually starts and presumably the jury is picked, or excuse me, sworn in. Doesn't look like that's what's happening. The only reason he would do it now is basically to try to have Zimmerman immune from civil liability. Even if there's an acquittal, you may remember the O.J. Simpson case, even if there's an acquittal, that does not stop the family of Trayvon Martin from bringing a wrongful death claim against Zimmerman, presuming that George Zimmerman makes money from the sale of books or anything else. that could be allowed. They've already sued the Homeowners Association, and apparently there was a settlement, and that's sealed, but there was a settlement in that regard. So the only other monies seemingly that exist would be any monies that Zimmerman might in fact make from somebody paying him for a book or a show or something along those lines. With that said, I do not think it was a bad move at all for the defense to not proceed on your stand your ground motion. I've never thought it was a very strong defense. I think that good old-fashioned self-defense is the defense, and that's the direction they're going in. Stand your ground would have exposed Zimmerman to excruciating and intense cross-examination by the state a mere 2 or 3 weeks before the trial. That's the last thing that the defense would want, is to have their client on the stand and then have a trial 2 or 3 weeks later. One, it would take time away from the trial preparation, and two, it would expose their client to incredible questioning, which is the last thing you want to have happen. So I think, and I don't think this judge would have granted it. We're seeing almost every pretrial motion by the defense that was not granted by the judge. So I think that for her to have ruled on that, I think the odds were very slim, and I think it was a good strategy move from a defense perspective not to have a stand your ground hearing early and simply to proceed in trial, which is what they're doing with a self-defense claim.
All right, thank you very much. News 13 legal analyst Mark NeJame with us through these proceedings. Thank you so much for that insight.
Thank you.